Hi, friends. My name is Rajan Goel. I'm a registered migration agent at Aussizz Perth. Today, we are going to talk about visa refusals and how you can appeal those decisions in the administrative tribunal. So, we're going to talk about the process. We're going to talk about what you can expect in the AAT process and how you can possibly win the cases as well. Okay, now we all know that when we apply for visas, the visas get refused as well. So there are thousands and thousands of people in Australia whose visas do get refused. But fortunately, if you are inside Australia and if you had lodged the application while you were inside Australia, you would have a right to appeal that refusal decision in the tribunal. Right? So all hope is not lost. So as soon as you get a refusal, so it is not end of the world. You have to look at certain things after you get a refusal, which I'll talk about in a second. But you can definitely, if you're inside Australia when the refusal happens, in most circumstances, you would be able to appeal that decision in the Administrative Appeals Tribunal. Now, Administrative Appeals Tribunal is an independent body, which is independent of the Department of Home Affairs. They are required to listen to conduct the visa appraisal again. They will hear you out and they will conduct the hearing and give you a fair and just and economical decision. So first of all, when your refusal happens, the first thing that you must notice is whether you are on a bridging visa or you are still on the substantive visa. So, for example, somebody who comes here on a visitor visa has applied for a student visa, and after a month's time, they get a refusal for that student visa. You have to look whether your bridging visa has already been activated or your visitor visa is still there. So if your visitor visa is still there and your bridging visa has not come into effect yet, there could be plenty of options, such as you can apply for a student visa again, addressing the reasons in the refusal to the department rather than going to the tribunal, because because the benefit of doing that would be that the fee for the department would be lesser, and perhaps the waiting time, the processing time for the department is a lot lesser than the tribunal as well. So if you've already got a substantive visa, when you receive a refusal, you should look at the option of applying for the visa again instead of going to the tribunal. But if you are on a bridging visa, when you get a refusal, when you get a visa refusal, your options obviously reduce to a lot of extent. You cannot apply for many of the visas onshore anymore. And the only option that remains, sometimes the only option that remains is to apply for the appeal for the visa that has been refused. And as I said, fortunately, you do have the right to appeal when your visa gets refused while you're inside Australia. Uh, you have to note that there are very strict timelines within which you have to apply for the to the tribunal. If you miss those deadlines, if you go beyond those timelines, your right to appeal is will no longer be there, and you will never be able to appeal that decision, and you might just have to leave the country after that. So make sure you appeal the decision within the required timeline. Generally speaking, for visa refusals, it is 21 calendar days. The first day being the day when you receive the refusal decision is not counted generally. So the 21 days start from the next day, from the day you've received the refusal decision. The visa cancellations could have a much lesser time period within which you have to appeal. It could be as less as 7 calendar days. So make sure you actually lodge your appeal within those required timelines. All right, so we could appeal the decision. So once you make an application to the tribunal, which you can make online as well, within the required timeline, your bridging visa, which you got because you made a substantive visa application, will continue as it is. You don't need to apply for a new bridging visa. The bridging visa will automatically continue as soon as you lodge the appeal. The department receives the information and they change your bridging visa A to indefinite period, and it will continue until your case gets decided by the tribunal. So you don't have to worry about the bridging visa. You will continue to have the same study rights or working rights which you had on your existing bridging visa A when you appeal the decision. Now, tribunal time tribunal can take a lot of time before they hear your case. Uh, in some cases, they could take up to 2 years, or normally, generally speaking, tribunal takes around 1 year for student visas as well. In that time period, of course, as I said earlier, you will continue to have study rights or work rights. If you don't have work rights, for example, you can apply for the work rights as well. But of course, that might go into consideration that if you, let's say, if you got a student visa refusal, and if you apply work rights during the processing or while your case is in the tribunal, uh, tribunal might say that you've applied for the work rights, you might not have enough money for the studies that you actually were trying to prove in the first place. So you have to make sure that all those considerations are met as well. But definitely, you can show financial hardship and apply for the work rights as well. If you don't have the study rights, you can apply for the study rights. And normally, you should always continue studying while you are waiting for the tribunal to come back to you. Because by the time tribunal will hear your case, as I said, it could take up to a year before the tribunal will hear your case. And if you continue to have good grades, if you continue to go to the college in a proper manner, this will obviously have a very, very positive effect in front of the member that will be hearing you in your student visa hearing. So make sure you use that bridging visa, the time period during the processing of the AAT application in a positive sense. I mean, in the student visa relevance, you must study, you must continue to study and get good grades if possible. If you've been refused another visa, for example, let's say a 485 visa, a subclass graduate, temporary graduate visa, or you've been refused a permanent visa or some other visa, you could even utilize that time period to gain some work experience for a certain skills assessment and possibly apply for expression of interest, or you could use it positively in any other manner which could help you gain PR in Australia. And by the time, if you could get invited again during that processing time itself. And if you do that, and if you're able to launch another visa inside Australia, you can simply withdraw your tribunal application and then continue waiting for this another visa that you would have applied for. So yes, so the processing time of the tribunal must be used in a positive manner. You should either, if you study or gain points or gain work experience during the processing. That's very important. Once your visa gets refused inside Australia and you are on a bridging visa, you actually get barred by Section 48 of the Migration Act, which essentially means that you can only apply for only a limited number of visas from inside Australia. You could apply for visas such as partner visas, medical treatment visas, subclass 491 visa, subclass 190 visa, subclass 494, which is an employer-sponsored visa. So all these state-sponsored visas, the subclass 494, which is an employer-sponsored visa, can still be applied for if you meet the eligibility criteria during your case is being when your case is being processed by the AAT. So you have all those options open to you still. So as I said, all hope is not lost. We can use that time period for a number of things and carve out another pathway for PR in Australia or for something else that you might wish to. Even after the tribunal hearing, you could lodge an appeal to the federal court if you think, of course, the matters get very complicated after that. If you think that there's a mistake in law made by the tribunal, you can even go to the federal court and then to the higher courts as well, even after the tribunal has refused a decision. So there are further appeal options even after the tribunal has refused your application. Now, tribunal has many powers under the Act. Tribunal can either affirm the decision. Affirmation of the decision means that the tribunal agrees with the department's decision and they will affirm the department's decision, meaning that your visa has been refused and the tribunal will agree to it. Tribunal can even set aside the decision and substitute a new decision. So tribunal can give you a new decision on the spot saying, okay, we grant you the visa. They can even do that. But most of the time, they don't do that. Tribunal normally remits the department uh, with some instructions. So what the if the tribunal, if you, and that's like winning the case in tribunal. So like for example, if your student visa gets refused on the grounds that you were unable to show sufficient funds, and then when you show, and when you, if you prove to the member that you've got sufficient funds for the student visa, then what the member will do is member will send the application back to the department with the instructions that the funds criterion has been met. You can look at some other criteria, and if you're satisfied that all of the criteria is met, kindly grant the visa to the department. So this is called remitting the visa to the department. So this is what normally the department does. They remit the application back to the department with certain instructions, which mostly contain that a certain criterion for the visa has already been met, and the case officer has no power to look at that criterion again. So if the case has been remitted by the tribunal member to the department saying that the GTE criteria has been met, then the case officer no longer has the power anymore to look at the GTE criterion again, because that criterion has already been decided by the AAT, and they cannot look at that criterion again. So yes, so as I said, when your visa gets refused, especially when your student visa, if you and it could take up to a year before the tribunal hearing comes up, and during that year, if you continue studying in a proper manner and have good grades, we'll show all of those things to the member, and of course, this will have a great benefit to the member in judging whether you are a genuine student or not. Of course, the department did not have this benefit when they refused the visa. They did not have this benefit of looking at your 1 year of worth of study, which the member will get, and this will definitely have a very positive effect as far as your student visa is concerned. So, student visa, if we specifically talk about the student visas, student visas can generally be refused on three grounds, or in other words, most commonly, student visas get refused on three common grounds. The first being that if you're not enrolled in a course of study at the time of decision, then the student visa will have to be refused by the case officer. Of course, the student visa can only be granted if you are enrolled in a course of study. Sometimes what happens is that your COE gets cancelled for some reason, and you are no longer enrolled in a study, and the case officer can refuse you on that ground because you were not enrolled in a study at the time of decision of the student visa. Then your visa would be refused, and you'll have to go to the tribunal. Or the second criteria could be that you are normally required to show a certain amount of funds in a student visa application. Sometimes you are not able to show the correct amount, or sometimes the evidence is not proper as is required by the law. Then the tribunal then the department obviously can refuse on the grounds that you do not have the sufficient funds, which is required by the law for your student visa. In these two grounds, let's say if the visa gets refused on these two grounds, the first one being that you were not enrolled in a course of study, and the second one being that you did not have sufficient funds. When you go to the tribunal member is only going to look at these two these two reasons. They're not going to look at the genuine student temporary entrant criterion and determine that. So let's say if your visa has been refused because you did not have sufficient funds, or your evidence was incorrect, the tribunal member at the hearing will only ask you to give them the evidence of the funds. They're not going to ask you whether you're a genuine student or whether you're doing your studies properly or not. They're only going to look at this particular criteria on which you have been refused a visa by the department. And once you satisfy this particular criteria, there's no further. Tribunal member will generally not look at any other thing and will remit the application back to the department, saying with the instructions, obviously, that the funds criterion has already been met. And similar would be the case when you get a visa refused because of the fact that you were not enrolled in a course of study. If you give them the proper COE to the tribunal member, then your visa could be remitted back with instructions that they are enrolled in a course of study, and the department can look at the other criteria again. Like, for example, Department refused you the visa just because you did not have sufficient funds, and now the tribunal member has given the application back to the department saying that the funds criterion has been met, the department can still refuse again on the ground that you are still not a genuine student in their opinion. And if they do that, you will have the appeal right again, and you can go to the tribunal again within those required timelines. But the third most common factor on which a student visa gets refused is the criterion which states that you must be a genuine temporary entrant. So which is generally called GTE criterion. So the department most commonly refuses the applications uh, uh, on this ground, the student visa applications on this ground, because they do not think that you are a genuine student, and they refuse the application. So when you appeal such a decision, tribunal member will then look at you for this criterion. They'll look at every aspect of your history. For example, they will look at your circumstances back in your home country. They will look at your circumstances in Australia. They will look at the fact whether the course that you're studying is related to your past studies or experience. Although reasonable change of uh, pathway is allowed under the ministerial directions. So the tribunal, like let's say for example, you've studied bachelor's of commerce from your home country, and you've now come in masters in IT. So this is a little bit change of pathway from what you've done before, but this is not prohibited under the law. A student can do that, and the tribunal member will take your statement into account as to why you've done that. As long as you're able to properly explain as to why you've done that, why you want to change your careers, and why you want to take a study which is different to your past experience, it should still be fine as long as you're able to convince the tribunal member. So these are the things. So the tribunal member will look at all these aspects again in a fair manner. And in my experience, tribunal members have always been very fair. They will go by the law. They will uh, give you they will give you an opportunity to sit in front of them and explain your circumstances in a proper manner, in a candid manner. They will ask you questions in order to satisfy themselves whether you are a genuine student or not. Um, so I'll just and they will look at the law exactly like it is. They will not have any biases, which unfortunately the department can sometimes have. And for we've seen that the department has made so many wrong decisions in the past, which fortunately for us, the tribunal member are very fair, and they will remit the application back to the department if such a thing has happened. Now, as I was telling you earlier, tribunal, there is a waiting time before tribunal can hear your case. It could be from a year to 2 years to 3 years in some of the visa subclasses. But that doesn't mean, so let's say you've just been refused a visa just because you were not enrolled in a course of study. You can, if you've been refused a visa just because on this objective ground, you can request the member to give you a decision without having the need for a hearing. Because, see, the visa has simply been refused because you don't have a valid COE. If you are able to get a COE, let's say the next day after lodging the appeal with the tribunal on this ground, you can write to the tribunal that the only reason why my visa was refused because I did not have the valid confirmation of enrollment. Now I've got that. Kindly have a look at it, and if you are satisfied, kindly grant me the visa as soon as you could, or kindly remit the application as soon as you could without the need for a hearing. Because in this case, there's no need for a hearing. A simple my visa was refused on this one particular ground, and that one particular ground has now been satisfied. So, and the tribunal members and the tribunal will uh, to fast track your case, will help you out and can decide the case without having the need for a hearing. Of course, they also want to fast track cases as much as they can. It just decreases their workload as well. And you can get the application remitted back within a month or within 2 months, depending on how busy the tribunal is. So they can consider such requests as well. Okay. Um, so yes, but otherwise, let's say you've been refused on GTE grounds, tribunal members will generally have a hearing to have a, even if they are happy with your submissions, obviously you will get the chance to prepare a new statement of purpose. And the other thing is that the tribunal member decides the case uh, like in a very neutral manner. They won't look at how the department interpreted your circumstances. Now, department could have thought that you are not a genuine student, but that would not generally influence the minds of the members. They will look at your case in an entirely independent manner without having any effect of the things that the case officer might have written against your case in the refusal decision. So you can, and you can provide all the documents all over again. Of course, the documents that have been provided in the visa application will be taken into consideration by the member. You cannot simply say that, okay, don't look at those documents which have been provided earlier. Those documents are there, and the member will obviously take them into consideration. But at the same time, you can provide whatever extra things that you want to provide. You can write a new statement of purpose uh, addressing the genuine temporary entrant criterion, and you can provide any other evidence that you want to provide in order to able to in order to be able to prove that you are a genuine student and you are here to study and you will go back after your studies get finished. So it's altogether entirely new case. So nothing from the department will influence the member. Of course, the documents that you provided will be taken into consideration. As far as the GT criteria is concerned, the member will objectively look at your circumstances in your home country, whether you've got incentives to go back to your home country. They will look at your immigration history. They will look at your the value of your course that you are doing in Australia. They will look at all these things which they are required to look as per the ministerial directions and which they're required to look as per the law. And they will try and have an objective they will look at all these things in a fair manner. So you've got a great chance. And as I said earlier, by the time a hearing comes up, you will have the benefit of showing the member that you've studied properly during the past 1 year, and you've got good grades perhaps, and all those things would be weighed positively in your case. All right. So these are the things that will really help you out in the tribunal hearing. Now, the fee for the tribunal is pretty high. It used to be less, but it got doubled a few years ago. Now, the fee for the tribunal application is 3,374. You can ask for a 50% reduction of this fee, but you'll have to prove that you are in deep financial hardship. But in case of student visa refusals, I would normally recommend don't say that you are in financial hardship, because when you had applied for the student visa application, you had actually mentioned that you've got sufficient funds to cover your expenses and your studies in Australia. So now when you tell the tribunal you've got severe financial hardship and then asking for the reduction of the fee, from that perspective, I think it won't go down very well with the tribunal member. They would certainly ask this question as to why did you then declare that you've got sufficient funds when you're now declaring that you've got financial hardship. It wouldn't make much sense. So the normal fee for the tribunal is 3,374. You will get 50% of it back if you win the case in the tribunal. And as I said, winning means that if the case gets remitted to the department, that's also winning. You will still get the 50% of the money back if you win the case in the tribunal. Only in the case of affirmation by the tribunal, that is when they agree with the department's decision, you won't get any money back. And of course, then you will either have to leave the country within the next 35 days, or you can appeal the decision in the federal court or federal circuit court or federal full court of Australia, and even go to the High Court if you wish to. All right. So after the AAT decision, even if you don't want to go to the federal court, you can also apply for a ministerial intervention. But when you apply for the ministerial intervention, your bridging visa A, which you had during the AAT process, that won't continue. You will have to apply for a bridging visa E. Now, there are certain drawbacks of having a bridging visa E. You might have to apply for work rights. You cannot travel outside of Australia. If you do, you will not be able to re-enter Australia during that period. You can apply for the ministerial intervention is a different pathway. So ministerial intervention is done because you might not have avenues available under the current legislation, for example. For example, if your visa gets refused because you have health issues, but you've got compassionate and compelling circumstances, you've been living in Australia on various temporary visas for the last 10 years, you've lived your whole life here, you've got kids and family members, then you can also apply for ministerial intervention, um, and, 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 and sort of request the minister to grant you the visa, even if there is no provision in the law to grant you the visa because of your circumstances. Um, yeah, so of course, if you've got a health condition, you could generally not be granted a visa uh, because there's a health criteria that needs to be satisfied. But the minister can go beyond the law and still grant you the visa if you satisfy certain ministerial directions under which the minister intervenes and gives you the visa. Okay, so these are the options still available, the ministerial intervention. But this can only be exercised once you've had a no from the tribunal. Once the tribunal member has given affirmation to the department's decision, only then you can go ahead and apply for the ministerial intervention as well. But of course, if you think it is a mistake of law that has been made in the tribunal, then you don't need to go towards the ministerial intervention route. You can simply go towards the federal court and get your decision there. So this is how the AAT process continues. So as I said earlier, when your student visa or any other visa gets refused, all hope is not lost. You can appeal the decision. In my experience, and as per the recent statistics that I had read somewhere on the AAT website, I think more than around 60% of the decisions that are appealed in the tribunal get sent back to the department with the instructions that the criterion that they refuse the visa on has been met. So you've got a very good chance of getting the visa decision remitted back to the department, even if your visa gets refused. So just as I said, specifically in the case of student visas, just continue to study, continue to attend your classes in a proper manner, get all those letters from your college or uni stating how you've attended classes and how you've got good grades, and present them to the member. Those will have a very positive effect on the member. The second, if you get refused some other visa, for example, a permanent visa, even if you do not have any scope of winning in the AAT, you could still use that time to prepare for some other occupation or to gain some work experience or to gain some extra points, and perhaps lodge a new expression of interest and get re-invited in your occupation. So you can do all those things while you're waiting for the tribunal decision. So this is the AAT process for visa refusals. You can come to us for AAT. We could write submissions for you. We can accompany you to the hearing in the AAT, and we can help you out in every which way as far as your AAT case is concerned. We'll make sure we address any deficiency in law, or if the case officer has made a legal mistake, we can point it out to the member. Of course, as far as the normal student temporary criterion is concerned, we can you can, as I said, write a new statement of purpose and convince the member that you are a genuine student, and we can help you with all that. And yes, so more than welcome to have one-on-one advice if your visa gets refused. But make sure you come to us within those deadlines, because after those deadlines have passed, there is no scope, and you cannot go to use the appeal option anymore, and you will have to use some other option, which we can advise on as well. But yes, so stay within those deadlines and apply for the appeal. So this is what the AAT appeal entails. Let me have a look at the questions. I have 85 points for 189 and 90 points for 190. Currently employed as a chemical engineer in WA. Do I have chances in the new financial year? Yes, WA, definitely you have good chance of getting invited in the new financial year. Chemical engineer is still on the WA occupation list. You've got good points, and we are hoping that the invitation rounds will start coming in August or September. And once the invitation rounds start coming in, you will have a good chance of getting invited, especially if you're a graduate of. Or should I take up a 186 DE instead? See, if you've got the option of 186 a direct entry right now, if you've got an employer who's willing to sponsor you, and you meet the 3 years full-time work experience criterion, then I think you should go for 186, because there's a lot more certainty with a 186 application, because you just have to lodge an application. It's not like somebody's going to issue you invitation before you can apply the application. So just go ahead. If you've got the employer who's willing to sponsor you, then and you meet the criterion, go for 186 DE. Why wait for 6 more months and not be certain whether WA will invite you or not? Tasmania, painting 85 points. Yeah, I think if you meet the state nomination criteria for Tasmania, yeah, certainly 85 points is a very good score. But they've got some additional criteria as well. Make sure you meet that. What should be the best option is TR expires, painting occupation. See, when your TR is expiring now, of course, another student visa is always an option. But if you've got the required work experience, let's say you've got 2 years of full-time work experience, you can also think of getting sponsored by an employer. Of course, you'll have to find an employer who's willing to sponsor you. So go for that, the 482 visa. Not only will you start getting paid in that occupation, you will gain more points, and you will have a pathway to PR through that path through the 482 visa as well. And in the meantime, you can continue with your expression of interest and wait for an invitation from the state government. What is the chances of getting 491 in WA for civil engineer to the... See, WA is at the moment closed, but civil engineer is a priority occupation in WA. So high chances of getting invited at 75 points as well. People were getting invited 75 points, the civil engineers in the rounds, some of the last rounds that were happening in this year. But the WA will only reopen in the next financial year now, as they're saying. They've exhausted their quota for this year. And we can hope to have invitation rounds held in August or September, and hopefully you'll get invited. Yeah, why not? I've lodged UI in December 23, 80 in 491, offshore civil engineer without work experience. Is it possible to get an invitation this financial year? 80 in 491 offshore. So I'm not sure which state you've lodged the UI for. WA will prefer onshore candidates over offshore candidates, but some of the other states will like for example Victoria can invite you for 491 as well. Victoria does not go by the points; they go by different parameters. Like if you've got superior English, they'll prefer you. If you've got skilled experience, they'll prefer you. If you've got a skilled partner, they'll prefer you, and stuff like that. So yeah, make sure you've lodged for all the states that you're eligible for. For example, you could be eligible for NSW, South Australia, Victoria, WA, and then you can maximize your chances. In JRP, can I complete within 1 year? Yeah, Job Ready program is a 1-year program normally, but because TRA is ridiculously busy, apparently, they delay the decision. Sometimes the decisions could be delayed by 2-3 months, 4 months, 5 months as well. So TRA is taking a long time sometimes, firstly to approve your initial hours and then to give you the final assessment. So they are sort of dealing, but otherwise JRP is supposed to be a 1-year program where you have to work for 1 year full time and complete it. But normally, because of the delays by TRA, which is the assessing body, the JRP could take a little bit longer. But the requirement still remains the same. That is, you only have to work for 1 year full time. That's it. In JRP, up to how many employees can I work? I think you're meaning to ask me how many employers can you work for? You can work for up to 5 employers in Job Ready program, but you have to do half of the hours or half of the time. You have to work with one employer, and that doesn't have to be your first employer. It could be your second or third employer. but half of the time has to be done from one employer. Otherwise, you can have up to 5 employers as well. Okay, I've got 6 to 7 years of experience in teaching in engineering fields. Can I get skills assessment? I did masters in civil engineering. See, assessment of an engineering occupation does not require any experience whatsoever. Uh, it you so it is the engineering skills assessment is a qualification based assessment. So you have to go through what we call a CDR pathway if your degree is not accredited, where you have to make 3 career episodes. So you do not have to have any experience whatsoever to get a positive skills assessment for a civil engineer, let's say, from Engineers Australia. Just trying to look for the questions on Instagram. Just bear with me for 1 second. What's the turnaround time from visa lodgement to visa grant? Well, it depends on a number of factors. So I'm hoping that you're asking me when after you have lodged the actual visa application, and not just the state nomination application or the expression of interest. So visa application could be granted earlier or later, depending on the occupation that you've nominated. For example, if you're a registered nurse or a teacher, your turnaround time could be much less. If you're an accountant or an IT person, it could take up to 1 year. Uh, and can I get points for my work? If you are teaching, it might not be possible. You must do engineering work. If you're getting the assessment for a civil engineer, then you might not be able to claim points for the work experience. How long does it take for 482 visa AAT? Well, AAT has got some published times on their website. It could take up to 2 years for the 482 visa sometime for the AAT, but you can have a look and go on the website and have a look on the published times. They published the average time in which the 50% of the applications get decided, and there's a timeline for in which the 90% of the applications get decided. So if you're lucky, your application could be decided within the 50% period, but it could sometimes be later than that as well. All right. Let us know if you need any assistance, as I said earlier, in your AAT cases, and we'll be more than happy to assist you. You can contact us anytime. Our contact details will be in the description below, and you could contact us anytime. Right, that's it for today. Thank you.